On November 21, 1963, Troy Leon Gregg murdered 2 innocent men while hitchhiking in Georgia. This crime resulted in a case, Gregg v. Georgia, that was brought to the Supreme Court due to arguments over the choice to impose the death penalty on Gregg. To this day, the death penalty remains a hot topic in American society, and one with very polarized beliefs on both sides, especially pertaining to its constitutionality under the 8th and 14th Amendments. The death penalty predates the United States. Instances of capital punishment occurred before the country's founding. The first instance of execution is documented in 1608, according to Patterson in Acculturation and the Development of Death Penalty Doctrine in the United States. The idea of capital punishment was influenced by British tradition. However, the colonies used it for serious offenses such as murder, rape, or sometimes religious crimes, while England's uses of the death penalty grew longer and longer during this time period. In the initial years after the founding of the United States, the death penalty was typically under local control and jurisdiction. The Commonwealth of Massachusetts took the first steps towards restricting the death penalty by reducing the number of crimes subject to each punishment. This is the first instance of the state controlling capital punishment, though the transition from local to state power did not finish until the 20th century. Feelings towards the death penalty continued to shift back and forth into the 1800s. The first national organization against capital punishment, the American Society for the Abolition of Capital Punishment, was founded as abolitionist efforts began to find success. In the year following the foundation of this organization, Michigan became the first state to abolish the death penalty. This action inspired 5 other states to follow Michigan's example, though some, like Iowa, Maine, and Colorado, saw the reinstatement of capital punishment again by the 1900s. The abolitionist movement gained ground again before the First World War as 9 states did away with the death penalty. However, 6 of the 9 states reinstated capital punishment by 1950. The 8th Amendment is often interpreted as an evolving standard and is used by abolitionists for the unconstitutionality of the death penalty. The death penalty is founded on a flexible standard found in the 8th Amendment to the Constitution. Although the Supreme Court's death penalty jurisprudence has demonstrated an overall trend restricting the power of the state in favor of the human rights of the accused individual. The first instance of the Supreme Court's influence on the constitutionality of capital punishment began with Furman v. Georgia. In a 5-4 victory, the justices found that the application of the death penalty in some cases violated the cruel and unusual punishment clause of the 8th Amendment. States now had to redefine the guidelines for sentencing the death penalty in order to continue distributing it as punishment for crimes. In 1976, in the case of Gregg v. Georgia, the Supreme Court again listened to both sides of the argument concerning capital punishment, ultimately influencing the attitudes in the United States as the death penalty was upheld in this decision. What is the case of Gregg v. Georgia? In 1976, Troy Leon Gregg, accompanied by Floyd Allen, was accused of murdering 2 men he was hitchhiking with, Fred Simmons and Bob Moore, and stealing their car afterward. Gregg was arrested and signed a written statement admitting to shooting and then robbing Simmons and Moore on the grounds of self-defense. Although, Allen told police that Gregg had shot both men with the intention of robbing them afterward. The jury found Gregg guilty of 2 accounts of armed robbery and 2 accounts of murder. The jury then decided to impose the death penalty on Gregg. On what grounds did the jury choose to use the death penalty? The murder was committed while the offender was engaged in the commission of other capital felonies, aka the armed robberies of the victims. In addition, he also committed the murder for the purpose of receiving the victims' money and automobile. Why did Gregg challenge the decision? Gregg challenges imposition of the death sentence under the Georgia statute as cruel and unusual punishment under the 8th and 14th Amendments. What was the Supreme Court ruling and the outcomes? The Supreme Court upheld the decision of the Supreme Court of Georgia and sentenced Gregg to death. This was the first death sentence accepted by the Supreme Court. It ended a moratorium on the use of the death penalty. Why did people support the death penalty? For years, death penalty debates centered around 2 main questions. Is the death penalty a better deterrent to crime than the alternate of imprisonment? And is the death penalty administered in a discriminatory way? Although legislation has focused on determining the constitutionality of capital punishment, it has done little to affect the stance of the general public. In 1986, 10 years after the Gregg v. Georgia decision, 71% of respondents to the Gallup poll claimed they were in favor of the death penalty. So what arguments is this majority making? The most prevalent pro-death penalty position is that capital punishment is a form of retribution, and taking a life for a life is justifiable because it serves as a form of vengeance for a serious criminal act. Additionally, many in favor of the death penalty believe it as a deterrent for people to commit crimes. Even though this argument carries less weight due to recent research invalidating the effect of deterrence, people remain convinced that deterrence exists. Nevertheless, the debate over deterrence is not even the most significant issue when it comes to pro-death penalty arguments. In response to whether or not the death penalty is administered in a discriminatory way, there is a noticeable difference between the high percentage of whites versus low percentage of blacks and Hispanics who support capital punishment. While the pro-death penalty side makes valid arguments that establish the basis for their position, the opposing anti-death penalty group looks towards the Constitution as a means of explaining their stance. Why did people oppose the death penalty? While a majority of the United States' population supports the death penalty, there are still a number of people that do not. Many organizations such as the American Civil Liberties Union, Amnesty International, and the National Coalition to Abolish the Death Penalty still fight to abolish and change the death penalty. Opposing the death penalty revolves around the fact that the death penalty is a cruel and unusual punishment that doesn't allow the chance for rehabilitation. In their view, capital punishment demonstrates a lack of respect for human life and prioritizes retribution. The death penalty is thought of as a torturous act. The Eighth Amendment prohibits cruel and unusual punishment, yet people facing the death penalty before the 1990s, and even years after, were forced to sit through a drawn-out death. Hugo Adam Badu, an American death penalty scholar, cites the electrocution of John Evans in 1983, illustrating the brutality and cruelty of capital punishment. It took 14 minutes and 3 electrocutions in order to completely kill him. The death penalty is supposed to be a quick and clean killing, yet many people like John Adams sat with their skin burning for a long period of time. People who disagree with the death penalty agree that the punishment of a crime should be proportional to the crime itself, but common human dignity should prohibit any person from using violent homicide as an instrument of social policy. The people opposing the death penalty believe that the death penalty not only violates the Eighth Amendment, but the 14th as well. The death penalty is an irrevocable punishment. It cannot be reversed. People in favor of the death penalty even admit that innocent defendants will occasionally be executed. Individuals that are executed because of the death penalty are denied the advantage of new evidence or new legislation that could potentially reverse their conviction or sentence. Following Gregg v. Georgia, the Supreme Court continues to limit the uses of the death penalty, and casualties from such punishment continue to decline. However, the punishment does still exist and can be done. The Eighth Amendment still acts as a standard for the constitutionality of capital punishment. However, the standard continues to evolve with the Supreme Court's decisions on major cases concerning said punishment. More and more, the popular and legal opinions lean toward abolitionist feelings. Even though the death penalty can still be a punishment for guilt in 31 states, the number of prisoners on death row that actually experience capital punishment continues to steadily decline. Only 14 states have executed a prisoner in the last 5 years, and there were only 28 executions total in 2015. How the death penalty is administered is also a growing concern with abolitionist efforts, especially since Oklahoma has recently performed an execution with an unauthorized chemical that its anonymous supplier had substituted for the execution drug required by state law. Such instances of illegal executions, as well as arguments over the financial aspect of capital punishment, continue to change public and professional opinions. In conclusion, although the controversy over the use of the death penalty in the United States dates back as long as it has been in use, the Supreme Court case of Gregg v. Georgia brought the issue back to the forefront of Americans' minds. Not only did the case end a de facto moratorium imposed by the Supreme Court, but it was the first time the Supreme Court accepted and agreed to a death sentence. This combination of factors makes this case significant in the history of the use of the death penalty. While the death penalty has been used markedly less in recent years than other times throughout history, the argument over whether it should still be an option has the country split in two and remains at a standstill.